Good morning, this is your Kelso Report for Thursday, February 14th. I'm your host, Clark Kelso. Happy Valentine's Day to everyone. Today, the Ninth Circuit has granted in-bank review in a case to consider whether a city ordinance requiring hotel operators to turn over hotel guest registries to police upon request violates the Fourth Amendment. In our second case today, a state court of appeal has reversed a trial court that inappropriately granted a JNOV on a theory of liability that was not alleged in the complaint, not litigated at trial, and not presented to the jury by instructions or the special verdict form. We begin with the Ninth Circuit. In Patel v. City of Los Angeles, a split panel of the Ninth Circuit upheld last July the constitutionality of a provision of the Los Angeles Municipal Code which requires operators of hotels in the city to maintain certain guest registry information and to make that information available to police officers on request. A hotel operator contended that the provision was facially unconstitutional under the Fourth Amendment because it authorized unreasonable invasions of their private business records without a warrant or pursuant to any recognized warrant exception. Following a bench trial on stipulated evidence, the district court held that the ordinance was reasonable and granted judgment in favor of the city, concluding that the hotel operators did not establish that they had a privacy interest in the guest registry information. Well, the Ninth Circuit, noting that a facial challenge is the most difficult challenge to mount successfully, rejected the plaintiff's claim, finding that the plaintiff had not introduced any evidence establishing that it treated the hotel registry information as private information. Now, the 2-to-1 majority was careful to note that it was not holding that a hotel owner or operator can never have a reasonable expectation of privacy in guest registry information, and it rejected the argument of the city that hotel owners can never have a reasonable expectation of privacy in the guest registries, simply because the regulation informs them that the police can inspect their registries on request. As the majority explained, an individual's otherwise reasonable expectation of privacy cannot be so easily stripped away merely by the adoption of a regulation authorizing searches of an item or location. So, it was clear that the panel majority tried to write a narrow opinion and clearly indicate that it was ruling as a matter of whether the statute was constitutional on its face, a difficult challenge to mount. Notwithstanding the majority's attempt to limit the scope of its holding, the Ninth Circuit yesterday voted to rehear this case in bank. So the plaintiff is going to get another shot with the full court. Next, we turn to a state court decision. One of the fundamental aspects of our system of civil litigation is that the parties generally control the theories on which their cases are tried. The plaintiff decides what causes of action to allege and what theories to proffer to support liability. The defendant decides how best to defend. As a general matter, the court should let the parties decide how to try the case, and in post-trial motions, the parties should then be held to those theories on which they decided to try the case. The court should not permit the parties to try the case on one theory and then introduce entirely new theories of liability or defenses in post-trial motions. Well, that is essentially what the trial court did in Simmons v. Ware, and the 4th District reversed. The case was a maritime wrongful death action. The defendant, one Chad Ware, owned a vessel that was being used for a live-on-board marine education program for students. The decedent, an adult chaperone on a trip, drowned while free-diving during a daytime excursion. This was during a program conducted by operators of the educational program. The jury returned a special verdict finding the company that operated the educational program, they were negligent cause of decedent's death, apportioning 20% of the fault to it, and finding the decedent was also negligent, apportioning 80% of the fault to him, but finding no negligence on the part of Ware, the boat owner. Well, at this point, the trial court inappropriately introduced into the case an issue of whether Ware and the operator of the trip were in a joint venture, making Ware vicariously liable for the operator's negligence. Based on that theory, the trial court granted the plaintiff's motion for judgment notwithstanding the verdict. The Fourth District reversed, noting that the existence of a joint venture was not alleged in plaintiff's complaint, it was not an issue litigated at trial, the jury was not instructed on joint venture liability, and the special verdict form asked no questions concerning the existence of a joint venture. Moreover, the trial evidence did not establish, as a matter of law, that Ware and the trip operator were in a joint venture. As a result, the court reversed the JNOV and remanded for entry of a judgment in conformity with the jury's verdict. Well, that's it for today's Kelso Report. Have a great day in the law.